Good afternoon and welcome to this panel discussion. It has been my great privilege to have chaired what has been a joint venture between the European Law Institute and the American Law Institute with Stephen Wise, who joins me on this panel. The progress we've reached, as many of you will know, is we have a finished set of principles. They were approved by the American Law Institute in May, by the Council of Ely last week, and the approval, we hope and trust, by the fellowship of the ELI is going to be completed this month. And so we've reached the stage of an enormous achievement. And that is a huge achievement, particularly, and if I may do this at the outset, praise the work of Christiana van der Horst and Neil Cohen, who have drafted this quite amazing set of principles. It has been a real achievement to get the law at least in tandem with one of the newly emerging markets. And I must also express our gratitude to all that have supported them, the membership committees of both organizations, the advisors, and many, many others, particularly those at the European Law Institute and the American Law Institute who provided the technical and detailed legal backup. We are extremely grateful. Today, we have a panel where we will again start to explain the purposes of this to those who are not presently familiar with them. And one of the principal objects of this, and I want to put this up front, is for you to ask questions in due course. And can I remind you now, please do not use the raise hand, which so many of you are used to doing. Use the Q&A. The raised hand simply will achieve nothing. So if you've got a question, use Q&A. I'm sorry to sound a bit like a headmaster, but this is a problem that it would be useful to get out of the way straight away. Now on the panel, who will be, after the explanation by Christiana van der Horst and Neil Cohen, will be comments from two people. One will be Christian Twig-Flesner, who is a professor of international commercial law at the University of Warwick. He's a particular expertise in this area of law, and he was one of the assessors of the project. And the other, and we're very privileged to have join us, Malte Backkatzenberger from the European Commission, which he joined in 2011 and has been actively engaged, amongst many other topics, in various aspects of the data economy, data strategy, and data governance. Now, I'm just going to say a word as to why do we need these principles. The objective is to address areas of legal existing uncertainty when it comes to data transactions and data rights. I think it's important to recall that data is different to other areas of matters in which people trade in several different ways. For example, it's what is commonly referred to as being a non-rivalrous resource. That shorthand expression, which I think is now getting into more general currency, means that basically data can be multiplied at no cost, can be used in parallel for a variety of different purposes, and by many different people at the same time. Secondly, the way data can be shared or supplied differs significantly from the supply of goods, and many transactions in the data economy don't have any proper analogy in traditional commerce. Some said, well, why do you need to do this? Because everything can surely be dealt with by the law of intellectual property. But that, again, on analysis, has proved to be fallacious. And data does need its own set of principles. Thus, there was a real market need for this, and also a need to help the legislatures and the courts for the future. And so these principles are addressed to them. And now Steve is going to add a word or two of his own before we turn to the other members of the panel.
Thank you, John. And on behalf of the American Law Institute, I'm delighted to be here, and I'm equally delighted that this project has gone so successfully, and we're moving to the final conclusion of the project. It's been a pleasure over the years working with Christiane and John and the advisors groups at the European Law Institute and its council to move this project along. It's been a terrific experience for everybody in that we've managed to take existing legal principles and pick and choose among them for application to these kinds of transactions. As John mentioned, we've avoided getting into questions of intellectual property, which are just not necessary for these commercial transactions. We've also avoided getting tangled up and trying to figure out, is this property or is this not property? And instead, the project has taken a functional approach to here's a transaction and here's a result we want, and let's figure out how to get from here to there so that we have ended up magnificently with a common set of principles that are not separate for civil law jurisdictions or common law jurisdictions, but that work quite well. We recognized at the very beginning of the project that we might end up with some variations in these principles, but through the terrific work of Christiane and Neil and the other participants in the project, we have this single approach that straddles the two kinds of legal systems. So it's been terrific. We've gotten industry input in these transactions, and at the ALI annual meeting this past May, we had 99% plus approval, and probably the under 1% that voted the other way hit the wrong button on their computers or something like that. So we're delighted to be at this point, and I'll ask John to then hand it back over to Christiane and Neil.
Well, that's all you're going to hear from the chairs until we get to the Q&A. And now I would therefore ask Christiane and Neil to begin the presentation of the principles on which they've agreed to do, again, a duet.
Well, thank you so much, John. And maybe I can abuse a few seconds of the slot allotted assigned to me for really thanking, in particular, Neil and Steve for this wonderful time. It's been amazing to work with them, a huge privilege. And actually, when we started this journey, we had no idea where we would end up, but it's been marvelous. We hardly ever quarreled. I can't remember us quarreling. We had very, very exciting discussions, and we ended up with one common set of principles. Now, without further ado, I will present the first few principles, part 1, which are principle 1 to 4 in the draft that is lying in front of you. I can be rather brief because part 1 just does what those introductory parts usually do. They set out the purpose, they set out the scope, and they set out some definitions. The purpose is described in principle 1, and principle 1 stresses that this is addressed at a number of different audiences, and also stresses what Steve and John have already explained, that this is to work in very different frameworks, whatever may be the data protection law around, these principles should apply in those different frameworks. Now, principle 2 on scope stresses that this is about large quantities of information as an asset, resource, or tradable commodity. What this is not about is, for example, software contracts. So what we call functional data. We do not deal with contracts about software. And we do not deal with what we call representative data. So data, the main purpose of which is to represent other assets or such as crypto assets, for example, or value. So that is not what we are dealing with. And principle 3, and this is the last one I will touch upon, sets out a range of different definitions. Let me just mention the first one, which is maybe the most central one, which is the definition of data. And we define data as meaning any information recorded in any machine-readable format suitable for automated processing, and that is stored in any medium, or of course, as it is being transmitted. So this is the definition of data we use. And with those few remarks, I would like to hand over to Neil.
Good afternoon, everyone. It's a real pleasure to be here. Like Christian, I'd like to use a moment of my time to express gratitude to the European Law Institute for the wonderful cooperation with the American Law Institute in this project, to our chairs, Lord Thomas and Steve Wise, for their really above and beyond the call of duty stewardship of this project. And finally to Christian, who wears so many hats, I can't name them all, but the one that I had the pleasure to deal with was co-reporter, where she brings both knowledge and insight to the process, and it's greatly appreciated. The title of the project, as everyone knows, is Principles for a Data Economy, Data Transactions and Data Rights. And what I want to spend a few moments on now is talking about the transactional aspects of these principles, and in particular, what we call data contracts. What principles 5 through 15, which are part 2 of this instrument, what principles 5 through 15 do is to identify and address 9 different types of contracts involving data. 5 of them involve transfer of or access to data, and 4 of them involve services related to data. And the principles take each of the types of contracts, and they're identified starting in principle 7 through 15, and provide a set of governing principles for those contracts. I'll talk about the types of contracts briefly, but I think that in many ways, the most important provision in this portion of the instrument is principle 5. And what principle 5 does is to set out a hierarchy of sources of governing rules for data contracts. And probably the single most important thing to note there is that one of the most prominent positions in the hierarchy, below only rules of law that cannot be derogated from by agreement, is agreement of the parties. Agreement of the parties is primarily what governs data transactions under these principles. So it's important to note that in this really emerging field, the principles provide for a major, indeed almost preeminent role for private ordering. And as a result, the main function of principles 7 through 15, which I address each of the types of contracts, is to provide default rules for those contracts, to provide rules for matters the parties did not address in their bargaining or did not reach agreement with respect to. Bargaining takes time. Bargaining has a cost to it, and not every transaction involves people thinking of every contingency. And so, as in every legal system, contract law provides default rules for matters that the parties have not addressed by agreement. The first group of contracts, and this is principles 7 through 11, again, they address contracts for the transfer of or access to data. And what the principles do is recognize 5 different functions that such a contract could have, and provide default rules that are appropriate for each of those types of transactions. In addition, because much legal reasoning is reasoning by analogy, to the extent that these principles don't provide an answer as a default rule, or the parties haven't bargained for something, each of these principles provides some assistance to a tribunal in how to reason by analogy from other existing principles in the legal system. Principles 7 and 8 are the simplest of the two, contracts for the transfer of data or contracts for simple access to data. In a contract for the transfer of data, the data is actually put under the physical control in the sense of the recipient, while in Principle 8, the recipient is given access to the data on the supplier's side, or perhaps the ability to port it. And the default rules there give rules about the nature of the access or the transfer and the characteristics of the data and the rights that the recipient is entitled to receive. In the US, we might call some of the default terms about the characteristics of the data warranties, implied warranties, and the like. They're terms about what the recipient has a right to expect. Contract for exploitation of a data source in many ways is a logical subset or variation of the first two. These are situations where while the recipient is going to have access to the data, in a sense, there are no real promises made about the quality or quantity of the data. It's whatever data is there is what the recipient gets. Contracts for authorization to access refer to very passive situations where someone who has the data or has the object that has the data in it authorizes the other party to access it, but has a very passive role in the transaction. And the default terms basically indicate there's no responsibility on the part of the supplier there other than not getting in the way. And finally, contracts for data pooling deal with situations where parties, and as the name suggests, agree to pool their data, and it's the mutual rights and responsibilities that are addressed in those default terms. The last four principles are about contracts for services with respect to data, contracts for processing of the data. The default terms are about the duties of the processor, data trust contracts, data escrow contracts. They seem rather similar in structure, but they have very different functions. Data trust contracts are situations where another party is entrusted and empowered to make decisions on behalf of the party whose data it is. And a data escrow contract, on the other hand, the main purpose is to divest the party whose data it is from the ability to make certain types of decisions and have control with respect to the data, and the default terms spell that out in some more detail. And finally, data marketplace contracts. This is about contracts to do matchmaking between suppliers and recipients of data. And again, Principle 15 supplies default rules, subject, of course, to the bargaining of the parties and the private ordering that they achieve through those negotiations. So those are the 9 types of contracts, and the default rules with respect to them are set out in detail in each of those 9 principles. The next portion of the paper, of the principles, is part 3, and that's going to be handled by Christiane.
Well, thank you so much, Neil. In fact, the next portion, part 3, is on data rights. Now, data rights are defined in Principle 3K. They're defined as rights against the controller of data that is specific to the nature of data and that arises from the way the data is generated or from the law for reasons of public interest. Now, that already explains the division of part 3. Part 3, again, comes in 3 chapters. We have chapter A on general rules on data, general principles of data rights. We have chapter B on data rights with regard to what we call code-generated data. And we have chapter C on data rights for the public interest. Let me start with chapter A. Chapter A starts with setting out the types of data rights that are being dealt with under the principles. And Principle 16 lists 4 types of data rights without being exhaustive. So we do not exclude the existence of further data rights, but those are the 4 main types of data rights we deal with. And they are the right to be provided access to data, by means that may, as we write in appropriate circumstances, include the porting of data. So there are various degrees of access, from read-only access to full portability. Then there may be a right to require the controller to desist from certain data activities. There may be a right to require the controller to correct data that are incorrect or incomplete. And last but not least, the right to receive an economic share in profits derived from the use of data. Principle 17 then sets out a similar hierarchy of norms as already set out by Principle 5, so I can refer to what Neil has already explained. So let me turn to Chapter B on data rights with regard to code-generated data. And Principle 18 sets out what we mean by code-generated data. Code-generated data is a term we coined, and it's already been taken over by a number of players, and we're very happy to see that. So by code-generated data, we mean data created through contributions of various parties, and those contributions can be of a very different nature. So Principle 18 lists various different types of ways in which you can contribute to the generation of data. So you can be the subject of the information coded in the data, you can be the owner or operator of an asset that is the subject of the information. You can generate data by an activity, such as by driving a connected car, by using a product or service. You can assemble or arrange data in a particular way or in other ways. And now the share which you have in the generation of data plays an important role in determining what kind of data rights you have or may have with regard to that data. But that is not the only factor. So the size and share of you have in the generation of data is an important factor, is a central factor that may give rise to a data right, but it's not the only factor. And Principle 19 lists a number of other factors in addition to the share which a party had to the generation of data. So there must be grounds put forward by that data to justify a data right. Then, of course, weight of any legitimate interests of the controller or third parties, any imbalance in bargaining power, and any public interest. And now Principles 20 to 23 just elaborate a little bit more on the grounds which a party may rely on for exercising a data right. I will not go into the details. There's a principle on access, a principle on desistance, there's a principle on correction, and a principle on economic share. Let me maybe just mention, because that's a particularly controversial a topic, that Principle 23 does recognize in principle the possibility that you have a right to an economic share, but only under very, very limited circumstances. And so that would be Chapter B on code-generated data, and Chapter C finally is on data rights for the public interest. So this is the type of data rights which we see emerging, in particular in statutory law, in regulation, so in all sorts of sectors. And Chapter C does not say when such a data right should be afforded by the legislator. Chapter C just says, if the legislator affords such a right, what would be some basic principles for such rights, in particular for data access rights. So we define proportionality, access under FRAND conditions, so conditions that are fair, reasonable, and non-discriminatory, the no harm principles, protection of third parties, and reciprocity. These are some general principles set out in our Chapter C of Part 3. And with that, I would like to hand over to Neil again for the next part.
Well, thank you. Thanks very much, Christiane. The next part, Part 4, as you know, is entitled Third-Party Aspects of Data Activities. And the first portion of that part, Chapter A, deals with the protection of third parties. This chapter is divided into 4 principles. The first of the 4 principles, Principle 28, is really the roadmap to the other three, and it ties them together because in one sense, it's really a definition or a high-level right that's described here. It tells us when data activities are wrongful, other than in situations we've learned in the earlier portions of the principles. Of course, if there's a contract between the two parties and there's a breach of contract, we don't need something else to tell us that that's wrongful here. But here we're talking about third parties, who probably have not been dealing with each other, or at least have not do not have a contractual relationship. And so we're told in Principle 28.1 that data activities are wrongful with respect to another party in any one of three situations. The first one is if they interfere with the right of the protected party that has third-party effects, such as intellectual property rights or the like, rights that are erga omnes rather than just inter se. The second is if a data activity by someone doesn't comply with a contractual limitation on data activities by that party, and this contractual limitation is enforceable by the protected party. As you all know, in different legal systems, there are various doctrines where someone who isn't a party to a contract can nonetheless enforce promises that one of the parties made to that contract, and someone who violates such a provision that's enforceable by third parties has engaged in a wrongful activity. And finally, it's a wrongful data activity if someone has gotten access to the data from the protected party by unauthorized means, breaking in or taking advantage of obvious and unintentional security gaps or the like. And so what we're told here is that these three types of actions are wrongful. They're set out in more detail in Principles 29 to 31. And we note in Principle 28.3 that it's possible under domestic law to justify actions that would otherwise be wrongful by doctrines of freedom of information, freedom of expression, and other grounds of justification that might apply generally. So again, this chapter of Part 4 deals with the protection of third parties in those three situations that are described. Christiane will now discuss the rest of Part 4.
Thank you so much, Neil. Indeed, Chapter B deals with a situation that is particularly dangerous often for protected third parties, which is onward supply of data. Principle 32 deals with the duties of a supplier in the context of onward supply, and basically states that where a party is under certain duties and restrictions with regard to use of the data, then that party, if it is at all allowed to pass the data on to another party, must impose the same duties and restrictions on the recipient, and take reasonable and appropriate steps to assure that the recipients and any further recipient will comply with these restrictions. So if you like, this is a due diligence approach. It's not an absolute ban. It doesn't impose full vicarious liability for anything that happens, but you have to exercise reasonable care, and in particular, you need to pass on restrictions and limitations and duties under which you yourself were laboring. And Principles 33 and 34 now deal with downstream recipients, and they address different constellations. Principle 33 is about direct actions against a downstream recipient in a situation where the first recipient was the good guy, if you like, and then the downstream recipient is the bad guy, and breaches those duties and limitations that were duly passed on to this downstream recipient by the first recipient. In that case, Principle 33 says there's a direct right of action. Principle 34 deals with a situation where already the first recipient is the bad guy and breaches certain duties, acts in violation with certain restrictions. And then, of course, if that is the case, the question arises, does that harm in any way the position of the downstream recipient? And what Principle 34 says in a nutshell, I can't give all the details, is that yes, it can harm the position of the downstream recipient if either the downstream recipient had notice of the wrongfulness on the part of their supplier, of its own supplier, at the time when the data activity is conducted, or failed to make such investigation when the data was received as could reasonably be expected under the circumstances. And then paragraph 2 lists a number of exceptions, like the wrongfulness was not material in the circumstances and could not be expected to cause material harm to a protected party, or the downstream recipient obtained notice only at a later point in time, or the data was generally accessible to the public. Now, that is in a nutshell the principles on onward supply. I can be rather brief on chapter C, which deals with the effect of other data activities, and we mean by other activities mainly processing of data. So Principle 35 lists the general duties of a party that engages in processing activities. Principle 36 then deals with wrongful processing, and as the basic rule states that when you engage in wrongful processing activities, normally you have to undo the processing, such as by disaggregating data or deleting derived data and so on. But there are certain exceptions in paragraph 2, such again, it depends on whether there was notice, the purpose, whether it was material in the circumstances, and so on. And last but not least, Principle 37 is about the effects of non-material non-compliance. So that is supposed to give more certainty to players in the data economy that have large and heterogeneous data pools to deal with. So they should not be discouraged from using that data just by the fear that there is a slight non-material non-compliance, such as some personal data in a large data pool that's otherwise composed of non-personal IoT data. That's in a nutshell the rest of part 4, and over to Neil for part 5.
Thanks very much, Christiane. As everybody knows, this is a quickly developing area of the law. And we're hoping very much that the promulgation of these principles will help with the harmonization of legal rules from state to state. But we all know that it would be unrealistic to hope that immediately the laws of all the nations in the world would become harmonized. And as a result, we have to face the possibility that a transaction that crosses state borders will be involved with states that have different legal rules. The transactions that are the subject of this project, of course, are ones that are particularly easy to cross borders. Parties can easily communicate with each other across borders, and nothing physically weighty has to be carried from one location to another. And so it is a situation that practically encourages international transactions and not just domestic ones. And when the law is different from state to state, legal systems have to deal with that. And that's the subject of part 5, dealing with multi-state issues. Principle 38 really has only a few points in it. One is about the application of really familiar choice of law rules of the forum. We're told in Principle 38 that the forum should apply its own choice of law rules for contract issues. And the choice of law rules around the world are not identical for contract issues, but they often follow a similar structure. Also, the forum should apply its choice of law rules for other areas, for which it has clear rules that are clearly designed for the issue at hand. Principle 38 also makes clear in the comments, though, that it doesn't deal with some choice of law issues and or other issues related to choice of law issues, such as how the territorial scope of a state's regulatory regimes should be defined. Principle 39 deals with issues for which a choice of law must be made by the tribunal, and there isn't a clear choice of law rule that fits the situation there. And it suggests or provides that what a tribunal, a court or other tribunal should do in that case is to select the law of the state that has the most significant relationship to the matter. And it presents a list of factors to be taken into account in determining which state has the most significant relation. Principle 40 deals with the rather minimal relevance in most contexts of the location of the storage of the data. Very often in data transactions, either those that we enter into as individuals or those that businesses enter into, very few people know where the data is stored or how many places the data is stored. And yet sometimes people say that should have an outsized influence in determining what law governs. We take a different view on that. The location of data should be relevant as a connecting factor for choice of law purposes. Only when the issue relates to the storage or rights in the medium, or perhaps as a tiebreaker in other contexts. And very briefly, Principle 40 also addresses whether a court exercising decision-making power with respect to data stored outside a state, or legislature exercising decision-making power with respect to data stored outside the state would constitute extraterritorial exercise of jurisdiction. And we say generally that should not be a problem. So that in a nutshell is a tour through all 40 principles. We realize it's been rather quick and necessarily a bit dense, but we hope that gives a good guide to what the principles address and how they address those issues. Thank you.
Well, thank you very much indeed for that very, very clear exposition and summary of the principles. And now can we move quickly to Christian Twigg-Klesner, but I do want to reiterate, we've got one question. Please start sending in the Q&As, and no doubt what Christian might say and what Malte will say after him will encourage questions. Christian.
Thank you very much. It's a great pleasure to be able to join this panel and give the perspective of a council assessor on the principles. As you will have heard from Niels and Christiana's presentation, these principles are incredibly rich. There's so much in them. They've managed to squeeze it into just over 20 minutes, but there's so much more in here. First of all, I think, well, what I want to do is pick out 5 or 6 very small points very quickly, because I could talk for hours and I won't force that upon you. Let me just first of all say that what's so wonderful about these principles is the way they are presented. Not only do you have very clear black letter principles, but you also have very rich explanatory comment, which explains precisely how these rules are intended to work, and incredibly useful illustrations, which make a lot of sense to somebody who tries to understand each principle. And as such, they fall in a very well-established tradition of presenting principles. And also what I find particularly helpful, I'm sure many colleagues will find useful in due course, are the very detailed national notes which have been incorporated, both looking at the US perspective and the much more diffuse European perspective. And I think in due course, this will make these principles a really useful and valuable tool. But it's not just the comparative dimension that's helpful, it's also the fact that the principles themselves as principles do, of course, interact with some underpinning applicable law. And here it's important to see how the principles might interact to some extent with relevant applicable laws, whether it comes to questions of remedies or other related questions. And here, the way the principles are presented will be incredibly useful. One thing I wanted to follow on is from what Neil said when he talked about data transactions. He mentioned Principle 5 and the hierarchy of different norms that will govern a data transaction. And there is a kind of gap filling or fallback provision in Principle 5, paragraph E, dealing with analogies. And that raises a very interesting question about the role of analogies in the way we adapt law to a variety of elements of the digital economy, of which data transactions are but one instance. And if you look at Principle 5e, you can see how any gaps which remain after looking at mandatory rules, the agreement of the parties, and the default rules provided by the principles themselves should be filled by reference to analogous transactions. And what you have to do then is to find another type of transaction which could serve as an appropriate analogy. And principles, the following principles do detail what kind of factors might help you identify what those analogous transactions might be. Now, analogies are difficult in any context, as we know. Just recognizing what the appropriate analogy might be is going to be difficult. But even when you can identify what suitable analogies might be, analogous transactions might be, there is the risk that the development of the analogous transaction in a different environment, the offline world, the physical world, may make it difficult to translate the analogy neatly into the context of data transactions. Years ago, an English High Court judge made the observation that analogies are a difficult thing to use when dealing with the digital context. However, I don't think in practice the reference to analogies will be a huge issue, because I think the reference to the agreement of the parties, which is going to be dominant in many ways, and the default provisions provided by the principles will answer most of the issues, if not almost all of the issues, that are likely to arise in practice. So Principle 5e is perhaps a useful fallback, but despite the concerns one might have about trying to draw analogies, it's unlikely to have a major practical effect, in the sense that it won't undermine the usefulness of the substantive principles. A second principle I wanted to just highlight in passing is Principle 33, which Christiane Wenderhorst explained earlier, in respect of the direct cause of action against third parties downstream in a what you might call a data value chain. And the approach is very interesting in a sense, because it provides a very clear direct right of action, which might not otherwise be available under normal principles of contract law, depending on which jurisdiction you're in. If I look at this through the perspective of an English common lawyer, we have some ways of allowing third parties to enforce obligations in a contract, but it's difficult to have obligations enforced against third parties unless you go through more cumbersome processes such as assignment of rights or other routes. So to have this direct right of action envisaged is actually an important step forward. And I think in many ways, it is not just relevant for data transactions and the data economy, but it is also likely to be something that we might want to look at in other contexts. For example, the role of global value chains generally, and other obligations that might be passed along a value chain and then need to be enforced. This is obviously a very controversial issue and a very difficult issue. And I noticed there's another Eli project looking at human rights in the business context, which could also be an interesting parallel that will pick up on this idea of direct action rights against third parties. More generally, Neil expressed the wish towards the end of his talk about the desire to promote harmonization of the legal principles regarding data transactions. And it's already clear, I think, that these principles will be incredibly influential. First of all, it is a co-production by two very important institutes, the European Law Institute, the American Law Institute, and it brings together two very different perspectives. There's a very strong common law perspective behind these principles, but this has been usefully combined with a very strong European perspective and a slightly different way of looking at data transactions. And the amalgam of these different perspectives has been, in my view, very, very successful. And that gives me hope that other common law jurisdictions outside Europe, around the world, including the UK, might actually take a closer look at these principles and be influenced by them when they consider reforms to their national laws on data transactions. But the driver might also come from a different direction. Some of you may be aware that the United Nations Commission on International Trade Law is actively exploring various initiatives in the digital economy and has recently identified data transactions as one area of interest. And it's really reassuring that the work on the ELI principles is acknowledged by UNCITRAL and is also recognized as something that might shape future developments. And that's really, really quite promising, I think. UNCITRAL also raises the possibility of perhaps trying to push analogies a bit far by trying to test how far the Convention on the International Sale of Goods might be a suitable model for data transactions, and I think rightly realizes that perhaps there are only some elements that might serve as workable analogies. For instance, the conformity provisions, which of course is also how the default rules in the ELI principles were developed by analogy with existing conformity approaches and appropriately modified. So I think I could go on, but I won't, because I think it's more important that we have time for proper discussion and questions. But what I found really exciting when I followed this project over the last two and a half years or so is just how complex an issue was distilled into some really quite clear, valuable principles. And all of the assessors for the European Law Institute, myself, Pascal Pichonat, and Kegelovich Steffens, we all agreed that we are looking at an amazingly solid project, an outstanding achievement, and I am really looking forward to seeing these principles formally published, of course, but also discussed and perhaps also applied in practice. I can see an obvious use case emerging very rapidly, and that is in the field of the Internet of Things, where data transactions might be really important when we come to complex smart systems, whether in industry or elsewhere. So in short, a landmark project, a great achievement, and there's lots more work to be done to see how these principles can now be put into practice. Thank you.
Well, thank you very, very much indeed, Christian Twig-Flesner. And now can I rapidly turn to Malte Backkatzenberger for the views he wishes to express.
Yeah, thank you, Lord Thomas. It's a great honor to be participant to this panel, and also having had the chance in the upstream development of these principles to discuss and exchange with members of the drafting team, including yourselves and Christiane and Pascal on what you're doing, because I think there's a lot of groundbreaking work here. My specific interests as a policymaker are probably in part 2, chapter C, data trust contracts, principle 13 and principle 15, and then certainly the data rights in part 3, but also the erga omnes extension of certain contractual rights vis-a-vis third parties. My own history is that, well, there was a big study exercise by the European Commission on a data ownership right. It was triggered, if I can say, from an industrial policy perspective. So I can only echo what Christian just said, that the industrial Internet of Things is one of those contexts where maybe there's a really great industrial relevance to these principles. It's also calling into, well, a reflection at least to what extent contractual freedom really works and what are the systems. And that's maybe the technological change of the interconnectedness of industry using IoT and cloud that really justifies this reflection on rights on data beyond personal data protection. And that's really, I think, a novel frontier that also I've been witnessing or trying to accompany at the European Commission side with various policy communications. And they have been mentioned also in the reporter's notes, which are, again, also I can only second Christian, very rich, and really recommend, I also recommend internally to read and use them. So the co-generation of data is one of the new things where since 2014, the Commission has been working on reflecting, do we need something? I see some colleagues also in the long list of very eminent participants that have been part of this discussion. Should we have a data producer's rights? And I think you rightly opt for no ownership for the very reasons that you said in the very beginning, Lord Thomas, that it's a non-rivalrous resource. And so the Commission's reflection also go much more into the direction of specific access rights. Now, these are tackled in part C, chapter C of part 3. But the current question, and we're really sitting on it as we speak, we had a long discussion this morning in the team and also this afternoon, I can say, whether there's a as a case to be made for from a legislative point of view to at least give certain data access rights as a default, and that's the rights that are granted. Now, I'm not exactly sure on the principle again, but it's about the normal use, repair, and onward sale of a right. At least you have a minimum rights when you exploit or use an object as a business user, but maybe also an individual. So we're at the very moment to define what is going to be called the Data Act. Subject to political guidance, we will may be able to take advantage of these very principles and actually maybe take verbatim inspiration on those principles. So it's really coming at the very right moment for us as a legislator. I think Neil spoke about harmonization. That's obviously a trigger word for the European legislator. We're trying to harmonize European legal systems, as very few countries are actually able to develop such a refined list of principles out of their own, or maybe they're all working for the waiting for the European Commission to take the initiative anyway. But it's especially in smaller countries, they would probably never be able. So the bigger jurisdictions in Europe would be taking the lead. But we're not seeing this really also. So maybe the Commission will take the lead on all these data rights. Now, one of the maybe more fundamental questions that I may be also putting out here for reflection and discussing is still, again, obviously, is data law something in its own right, or is data law the law of everything, because everything is data and all the information can be data, and depending on the context in which the information or the data are being generated, you may need to apply different rules. I think the principles show that it is possible, and that's really the great achievement, to distill horizontal principles that are actually common to this new class of an economic asset, and that makes sense to be applied across the board. And our big, I think, challenge as legislators is to keep also all the different domain-specific, sector-specific initiatives somewhat coordinating. That's, I think, our team's ambition, also through the Data Act, to bring some sort of harmony into this. So really, I would maybe just leave it at these comments, because we will see what the Data Act will bring. It's really subject also to a political steer. But the chapter, the part 3, is probably the most important one. Maybe to conclude, data trust contracts, data marketplace contracts, principles 13 and 15, that is something I'm currently negotiating in the EU Council and with the Parliament under the so-called Data Governance Act, where we also came to the conclusion, as you do, that neutrality is a very important element. And we felt that if the market is to really embrace this concept of data trusts and of data marketplaces, maybe even the legislator may need to ensure the neutrality of the providers, which the market could, I mean, you could legitimately say the market also could provide this, and there's maybe different ways to address and solve that problem. But that's been the decision by the European legislature. So I'm really happy and also a bit proud, I would say, to be having part of this exercise, and congratulate you once more on this rich and dense set of principles. Thank you very much.
Well, thank you both very much for such stimulating and, if I may say so, very encouraging comments for the work that has been done. And now, can I again, we have 3 questions already in the Q&A, and please think of some more. I'm going to, if I may suggest, take the second question as the first one, because it's more substantive, and we'll come back to dissemination, which is the first question, towards the end. And the question reads, it's from Joe Bankhoff: I may have missed the point, but what rules apply to the protection of a party's privacy in the use of data submitted in a commercial transaction for consolidation by the receiving party or onward sale? I think it probably would be helpful if we had an answer first from Christian, then Neil, and then the 2 other panelists might wish to comment.
Thank you so much for that excellent question. I can be brief. I would say the primarily it must be for the relevant data protection or data privacy regime, in particular if that is a mandatory regime, and usually those regimes are mandatory law. So it's primarily those regimes that would say what are the effects of onward sale or consolidation by the receiving party. To fill the gaps or where no mandatory data protection law would apply, we presented principles 32 to 34 as an answer. So we, and to a certain extent, I would believe that you can combine the application of mandatory data protection law and in particular principle 32, but also the other principles. So it's not an either or. I think they also can help in the application of existing and applicable data protection law. And principles 32 to 34 would try to give an answer. Principle 32 would deal with the duties of a supplier. So in particular, you know, imposing all the duties and restrictions that supplier was had to comply with on the recipient. Principle 33 and 34 would deal with the conditions under which you have an action against a downstream recipient. So that would be the answer given by the principles.
I think that Christian has really covered the point. I'd just like to draw everyone's attention to two provisions in the principles themselves. One is in Principle 1, paragraph 2, that is designed to make it very explicit that what we're not doing in this project is to create data privacy or data protection law. And we're not intending to amend or create it. And anything that we say that's inconsistent with governing data protection or data privacy law yields to those existing regimes. Much time, effort, and intellectual firepower has already been spent on developing those regimes, and we didn't see that as an area for our project to add even more. The other thing to note just very briefly is in the principles about third-party effect and protection of third parties, Principle 29 that we talked about earlier talked about rights that have third-party effect, and those include data privacy and data protection rights, and they're elaborated on a bit more in Principle 30. Those are just some references if you want to see how we addressed it explicitly in the principles themselves.
I was going to ask, before we turn to the next question, the two panelists if they wanted to add some comments to those answers and to the question. Malte, do you want to start? Yes.
No, thanks a lot. Maybe if you take the notion of privacy large, you could, at least from a European perspective, also include the protection of trade secrets, where there's European legislation, which actually very much also has this non-IP approach to trade secrets. It's not giving you an IP right on your trade secret, but gives you the third-party right. So it's very much the same thing. And then also, I think on the notion whether there should be any data rights under Part 3, that's one of the factors to take account, that others may have an interest that you don't have a right on the data, so you wouldn't have a tradable right in the first place that you pass on to someone. Thinking of someone who has maybe an access right now to data from his machine, but so to say, the industrial privacy of the manufacturer is a reason not to give him certain rights to just do anything with any of the data from this machine. That's maybe another facet to look at privacy in a larger sense.
Christian, do you want to add anything?
Yeah, just one small point, picking up on something I made in passing. Obviously, the principles aren't exhaustive, and therefore data privacy, data protection is something that's left to relevant applicable laws. And I think here there's going to be some interesting exploration to be done in due course as to how these principles might then work in the context of any given national or regional legal system where data privacy rights are at play. How does the interaction, the combination of the two work? I know it is one of the questions asked about, you know, what articles might be written about these principles in the future, and that's undoubtedly one issue that people will want to explore alongside policymakers, of course.
Well, thank you very much, and Steve is going to ask the next question.
Thank you, John. We have a very good question from John McGowan, and I think we'll start with Neil on this one. And that is, since this was such a comprehensive project, were there any areas or principles that you were unable to have included? What do you see the role of the American Law Institute and the European Law Institute in the development of those excluded areas? Is there something you wish we could have been covered, putting aside privacy and intellectual property kinds of questions?
Thanks, Steve. This is a great question. And of course, in any project, you have to have certain borders on the project. Otherwise, you cover infinite number of topics and it takes an infinite amount of time. So there are things that we chose not to address. One that we chose not to address, and I don't have regrets about, is the question of whether rights with respect to data constitute property. That's an area that has generated much more heat than light over the years. There are competing conceptualizations about it. And Christian and I came to the conclusion, and thankfully it was supported by others in the project, that it was unnecessary to resolve that as a conceptual or doctrinal matter in order to set out the principles we do have. As a set of functional principles, we were able to reach common ground without a resolution of that debate. And that debate, of course, is played out differently in database contexts and others in Europe and the US. So it was a choice we made not to include, which I think was a good choice. One of the effects, though, of not addressing that is that it did make it a little bit more challenging to address some matters that we didn't address. Just one example would be the use of data or data rights as collateral. That was something that is something that has significant commercial importance. When Christian and I were working on this, we discovered that different conceptualizations of what can serve as security for an obligation and led us to somewhat different ways of thinking about this. We had a common result in mind, but it turned out that it was just a bit too hard to reach consensus, not only about results, but how to get there. As a result of that, in the US process that's ongoing now about adapting our commercial law, including our law of secured transactions, to emerging technologies, we'll be addressing that domestically. I suspect that will happen in Europe too, either at the EU level or the domestic level. And there may still be room for organizations such as the ELI and the ALI to add more to it. But that was one that perhaps if we had had more time, we might have addressed rather than just having it lurk in the background. Christian may have some others as well, but that was the first one that came to mind for me.
Christian, anything you wish you could have covered in the project?
Well, I think our views, so Niels and my views, are pretty similar in that regard. So also I would have said security interest is something we might have covered, but then there were good reasons for both organizations to carve that out at the end of the day. And there are other areas which, of course, would be very interesting and challenging, but which we felt did not make sense in the framework we had created. Take, for example, all these IoT data and smart contracts and M2M contracting. That would be really, really fascinating. And I think it's important to go into that area, but it would have been very difficult to fit that into the framework we created and into the project as we had started it and as the project design as it was decided upon by both organizations. So that is something which is important, but it was not for us to deal with it in that project. Thank you so much.
Christian and Malte, anything you wish the project could have covered that wasn't covered?
Well, I think it was pretty comprehensive despite the omissions, but one thing I will find interesting for the future, maybe this wasn't for this project for all sorts of reasons, but I do think there's an underexplored consumer dimension, which one day I think people will have to turn their attention to. This wasn't the project for doing so, quite rightly, obviously, but I think some of the issues the project has dealt with do arise also in the context of consumer transactions. So it'll be interesting to see how the principles could one day be the basis for developing more consumer-focused provisions. And I'm sure the European Commission will keep an eye on that for that reason.
Malte, anything?
It won't be my team or the team I'm working in, but as I've seen also some intermediate versions, I spotted some gaps, but all the gaps that I would have wished to be filled have been filled. So I'm very happy with the outcome.
Good. Speaking from the American Law Institute's point of view, and the second part of the question about future activities, this whole project was an experiment between the European Law Institute and the American Law Institute on coming up with a topic where we had common interests and hope to have a common product. And it's worked out marvelously. And so I hope there will be future projects, whether they're linked this or other areas altogether, where we can work together with the European Law Institute. John, do you want to pick up the first question that came in?
Before doing so, can I echo Steve's remarks and hope very much that this will be the first of many projects to take forward. Now, can I go to the first question, which really is about taking this forward? And it's from Mihaela Karasan, which says, how can we use all these principles and to refer to them? Can we promote, share them amongst our peers? Can we write articles about them and their importance? I say here to all of that, but I'd much rather it come from both Neil and Christian and Malte.
I have a one-word answer. Yes, and please do, because the principles don't disseminate themselves, and they're influential the more people know about them. So yeah, please do write about them.
Christian, do you want to say something about the website that has been created?
Thank you so much, John, for mentioning this. Indeed, we have published, and in particular, the American Law Institute has published the tentative draft number 2 on its website. The council draft has been made available to the members of both organizations, but we thought it's important to also, present more condensed versions of it to the public. So a website has been created and is being worked on. So we're working on sub-pages on several topics. And so please, you find the relevant link when you go to the project websites of the respective organizations. In particular, when you go on the ELI website, you find the link immediately. And we're also working on, kind of short and condensed outlines, which we could use, for explaining the main content of the principles to people who may not have the time to read 300 pages. Thank you so much, John.
May I just say, before I go to the others, that the ever-efficient Thomas has put on the website the link, which everyone, I hope, can see in the chat function. And it is a marvelous creation of website. It's got excellent diagrams. And as people say, a diagram saves thousands of words. Not only do pictures sail 1,000 ships, but they save a great deal of explanation. But can I now turn to Christian and then to Malte as to publicity and taking this forward?
Thank you. I think the most immediate way of taking this forward for me will be to teach my master students in the autumn term about these projects. I teach a course on the digital economy and commercial law, and these will be a great fit to have an initial exploration. I think for a lot of us, that will be an interesting way of just disseminating some of these principles, and also find room for discussing and exploring them a bit further. But as I said in my short summary, I think it's going to be incredibly important to not let these principles end up on dusty bookshelves, but to really discuss them. They're incredibly important. They will be influential, I'm sure, both within the EU, within the US, but also via ANSI and other organizations on a global scale. So I think, yes, share them, yes, publish them. As soon as the final version is ready, get it out there. But I'm sure there'll be some publication plans which will in due course be confirmed as well.
Yeah, in our case, I can say, if we make use as a legislator of these, it means quite something, because it could mean that you find some of the principles reproduced in a European regulation. So I can't say whether that's going to happen, but we're working on the data act, we're working on legal drafting, and I think the really concise principles help a lot also our not always English native speakers lawyers to do good drafting. So I shared within the teams this document. What will happen is then a political decision. So that's how we want to make use of that. But also internally, I mean, it was very important, the illustrations that you give, they're helping already the conversation, saying that it's not some small team somewhere in the commission that has funny ideas about tractors and data from tractors, but that this seems to be a wider concern. And that's maybe also the feeling I got, at least, maybe it's confirmed, that this has strongly benefited also from legal advice practice, so that the problems that the principles aim to solve are real world problems, not just some academic problems that you can write about, but this really is the industrial problems that we might solve either contractually or in some cases maybe also by statutory law.
Thank you very much indeed. There is one final question, which I think we can take and still finish in 4 minutes. And it's from Karen Sain, which says, on the scope of the principles, when is data contained in machine-readable documents excluded from the scope? If a law firm creates machine-readable terms and conditions to the clients and transfers them, this is not within the scope of the principles. Right. Cristiano, do you want to, and Neil, do you want to deal with this very technical question?
Thank you ever so much. So I would like to point to Principle 2.1, which says, you know, the primary focus of the principles is on records of large quantities of information as an asset, resource, or tradable commodity. So we do not primarily deal with, you know, like bits of information which you provide like in order to convey a certain message to somebody. For example, our principles do not deal with information duties, even though theoretically also information you give to consumers, for example, is data. And so we wouldn't normally consider, you know, when a law firm communicates their terms and conditions to a client in order to enable that client to make an informed decision or to enable that client's machine to make a decision, we wouldn't consider the terms and conditions in that situation as something that's within the scope of our principles. Having said that, where of course, like you use AI to search thousands of terms and conditions of different firms and, you know, create very valuable data out of them, then again, the terms and conditions might be within the scope of our principles. So it's not a strict either or. So you can't really say, you know, a machine readable document is inside the scope or outside the scope. It depends on the perspective and on the legal issue at stake. That would be my answer, but Neil may correct me if I'm wrong.
There's no correction needed. I agree fully with what you said. Reference might be made to the definition of data in Principle 3 in this regard. And I think also, and as Christian, I think you mentioned the first sentence of Principle 2, paragraph 1, where we say that the primary focus of the principles is on records of large quantities of information as an asset themselves or a tradable commodity. Ultimately, as the question observed properly, almost everything is information and data if we have the broadest possible definition of those terms. And it's not incorrect to think of all these things as data. What we've chosen to do in this project is to pick an important economic subset of all the things that might constitute data or information and talk about rights and transactions with respect to them. And we hope that the drafting, both in the black letter of the principles and in the comments, helpfully delineates the line between the types of things we are addressing, the types of things that we're not trying to address.
Well, thank you both very much. And may I say to everyone, the panel, and to all those who've come, thank you very, very much. But I now leave the last word to Steve.
Well, thank you, John, and thanks also to everybody. And I remember 4 or 5 years ago when Neil and I met with Christian and a small informal group in Vienna when Neil and I were there for an UNCITRAL meeting, and we started exploring the concept of this project, and it has worked out way beyond our greatest hopes. So this has been terrific, and we look forward to continuing with this. There's a conference you'll see in the chat next month, and other projects both in this area and between the two organizations. So thank you very much.
Good day and good night, and well done, everyone, participants and panel. Thank you.